Hello there. Today I want to talk to you about estate planning for expatriates. The United States hosts the highest number of immigrants in the world, but increasingly Americans say they're looking to relocate permanently to another country. A large percentage of wealthy Americans are also interested in buying real estate overseas and living there at least part time. Now, while moving overseas is often a lifestyle decision, the practical implications of living abroad, including taxation and estate planning issues, they just can't be ignored. Escaping Uncle Sam is not as easy as hopping on a plane to some, far-flung location. Americans living overseas, they still retain financial obligations to the US government. And if not physically present in this country, they should have somebody who is legally authorized to make financial decisions for them. Expatriates who live and own assets, accounts, and property in more than one country need an estate plan that reflects their international life and lifestyle. This may require working with estate planning attorneys in each country where property is held and where they have some assets. So let's talk about living abroad and double taxation. Only two countries have citizenship-based taxation, so what we call double taxation, the US and another country called Eritrea. Now, double taxation means that US citizens living abroad could end up paying income tax twice on the same income, once to their home country and then once to their host country. Double taxation may apply to estate taxes as well. Although estate taxes affect only the wealthiest Americans, 92% of wealthy Americans are actively looking to relocate abroad in 2023. Now, foreign assets are subject to U.S. estate taxes, so any property an American citizen owns overseas could be subject to this tax if their estate is worth more than the exemption amount, which at the federal level is a little shy of 13 million in 2023. In addition to federal estate tax, some states also impose a state estate tax or inheritance tax. So the state of Maryland actually imposes both types of taxes. Now, estate taxes held in another country might additionally be taxed under that country's laws. Now, not all countries impose estate taxes, but some do, some don't. There are a few ways expatriates can avoid U.S. double estate taxation. The most extreme way is to renounce U.S. citizenship, a move that nearly 1 in 4 expats said that they would actually consider. Another option is to take advantage of the foreign death tax credit, which allows expats with property located in a foreign country to claim a credit on estate, inheritance, legacy, or inheritance tax paid to a foreign government. Now, trusts can also reduce estate tax liabilities. Different types of trust can be used for that purpose, including irrevocable life insurance trust, charitable remainder trust, and qualified personal residence trust. But because some countries do not recognize trust, a trust set up in the U.S. may not be valid in those specific countries. Let's talk about U.S. expats and international wills. An estate plan written with U.S. laws in mind may not be legally valid for American citizens who are living abroad. Someone who owns property only in the U.S. can likely get by with just a U.S. will. But depending on the country where the expat resides, if they own property and other assets in that country, it may be necessary to have multiple wills or an international will. An international will is designed for use in more than one country. 2 international conventions on wills authorize a foreign country to recognize a U.S. will. The Hague Convention on Form of Testamentary Disposition. For expats living in one of the Hague Convention signatory countries, their U.S. will could be valid in their country of residence, even though the U.S. is not a signatory. The adopting countries include most of Europe. Now, the International Will Statute, which is the Washington Convention, this convention creates a uniform law on the validity of an international will. Participating nations generally recognize a U.S. will if it conforms to the International Will Statute, which requires that wills include special language and follow specific execution requirements. Around a dozen countries, including the U.S., have adopted the Washington Convention. However, unless an expat state of residence has signed on to that convention, their international will may not be considered valid in their host country. So let's talk about the situs of wills. American citizens abroad, according to Expat Resources, notes that even if a single will controls the disposition of assets in more than one country, it just may not be practical for the estate's executor, who will then have to coordinate estate administration across multiple jurisdictions. It may be particularly difficult to administer assets located in non-English speaking countries. In such cases, a primary will, either a U.S. will or international will, could be combined with a separate situs will, a will that's specifically used in that certain country, in order to control the distribution of the assets. So in forced heirships, a separate will might not be advisable for Americans who acquire property in a forced heirship regime. Residents of jurisdictions that have forced heirship provisions may have restrictions on whom they give their assets to and how much each person may receive. Forced heirship rules vary by jurisdiction, but typically force a portion of estate assets to be passed to reserved heirs, whether it's children or spouses. Now, foreign and U.S. courts may apply forced heirship laws to portions of an estate that are subject to these laws. Now, living overseas can create legal complications that are best addressed in an estate plan. For example, the parents of minor children living overseas may have a guardianship provision in their will that names a U.S. resident as guardian in the event that both parents pass away. This will require more in-depth planning and an understanding of which laws will apply to the guardianship of your children. If the guardian is not a resident of the country where the children live, though, the children might have to be moved back to the United States. Additionally, without a legally recognized guardian accompanying them, minor children cannot typically leave the country in which they reside. Alternatively, a person in the host country could be named as a guardian in the will. Estate plans should always name backup guardians to supplement that first choice. Now, regardless of whom the parents nominate, the local court and laws determine who will take care of the children. For families living abroad, a local court, not a U.S. court, could have authority over the matter. Expat parents should understand which laws apply to guardianship issues and ensure that if there are multiple wills effective in different countries, guardianship provisions are clear and that they don't conflict in those different wills. Now, some other estate planning considerations for expats include financial and medical powers of attorney. Now, for financial powers of attorney, expats who retain U.S. assets need somebody who can perform financial transactions for them while they're out of the country. Now, actions like selling property, opening and closing accounts, and registering vehicles can't always be done remotely. So giving a trusted person a power of attorney lets them make those transactions on the expat's behalf. Now, a power of attorney can be open-ended till the end of time, or it can be limited, and it can also be revoked at any time. Now, let's talk about medical powers of attorney. A financial power of attorney can be set up to take effect at the time a person becomes incapacitated. But incapacitation raises healthcare questions that can only be addressed through a medical power of attorney, which authorizes a proxy, a person, to make medical decisions on another's behalf. It is advisable to make a medical power of attorney in each country where an expat resides. A U.S.-based power of attorney may not have the authority to make medical decisions in a foreign country. So you want to make sure if you're going back and forth or you reside in two different countries that you have these properly implemented. So you want to ask yourself, does your estate plan match your international lifestyle? Now, whether you're living overseas currently, or you have plans to relocate to a foreign country, or you just want to invest in property outside of the U.S., you'll have to adapt to a new culture and new laws, including laws that affect taxation and estate planning. Your U.S. estate plan documents may be inadequate to deal with legal questions raised by an expat life, putting your wealth and your legacy at risk. Now, careful international estate planning can help address the challenges of calling more than one country home. So due to the differences in laws, it may be necessary to work with attorneys in separate countries. Now, if you're an American abroad, I do recommend meeting with your attorney to see if your estate plan reflects your current circumstances. You can also have that attorney advise you whether or not to meet with another attorney in another country in order to put your documents in place. So I want to thank you for watching. I'm attorney Kelly Longtin from Kelly Longtin Law, and this is all about what needs to be addressed if you decide to live in another country or split your time between multiple countries. If you found this beneficial and you want to learn more about estate planning, please like and subscribe our page below.